This conflict of interest. You only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a minute.
Ain't no
I'm
victim
not
or
your
no
man.
loss, bro.
I'm not your, listen,
Hey,
listen, I'm
hey,
not your
look,
man.
look, sir.
I'm not your
Hey,
bro.
sir. Hey, sir,
Okay?
respectfully, you're Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody.
I'm not your bro. I'm not your man. And I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem.
All right, everyone. Today's court clip is a tense one. We're watching Judge Perkins deal with defendant who identifies as a sovereign citizen and missed his court date. His reason? He says he couldn't get into the Zoom hearing. That was the explanation he gave. The judge wasn't convinced and denied his request right away, which immediately set the defendant off. Missing court is serious, and the defendant's confident attitude didn't help him at all. The moment his request was denied, things went downhill fast. Let me know what you think as we jump into this heated courtroom exchange where Judge Perkins firmly takes control.
Sir, I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right.
Can I get a written articulation as to why you're denying the motion?
I'm denying the motion because
I would just appreciate a written excuse. Can I get a written articulation?
I'm not give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, and you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying.
I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying a motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of forum.
I insist that the court give me a written excuse as to why you're denying my motion so I can take that to the tenor, okay?
Well, you can insist all you want to.
Okay, I appreciate that. But I'm telling you, you're telling me to any of that. So I'm just asking that you can give me a written excuse that I could go take and complain against you on. Because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelmed.
At times, it's hard to tell whether this defendant truly doesn't understand the process or if he's just avoiding responsibility. He even demands a new judge, clearly upset by the ruling. But here's the reality. A judge isn't required to provide a written explanation when denying a motion, especially when that motion has no legal support. What stands out is how frustrated the defendant becomes after hearing no. Instead of accepting the decision, he keeps pushing back. This type of behavior is common in these situations and often leads to worse outcomes. People who follow this approach almost always lose in court and often end up paying more than they would have if they had followed the rules from the start.
So at the end of the day, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay? And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. because you're an Article I judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a
Ain't
minute.
no
I'm not
victim or
your
no
man.
loss, bro.
I'm not your, listen,
Hey,
I'm
hey,
not your man.
look, sir.
Meet your
Hey,
bro.
sir. Hey, sir,
Okay?
respectfully, you're an Article I judge under the Commerce Clause. Motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tender right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more
All right,
from
cool.
you.
It's cool. I appreciate
your
it.
record. No,
This
don't
due
interrupt
process
me.
this
I
a
didn't
due
interrupt
process
you.
violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They not prepared to present a case. I'm telling you. They're not prepared to present an injured party, sir. What we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever. Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have the opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
One surprising part of this hearing is how patient the judge remains. Many viewers might expect a contempt warning at this point. Zoom courtrooms seem to change how people act. Being behind a screen gives some defendants a level of confidence they likely wouldn't show in a physical courtroom. Once they start talking over the judge, it's harder to bring things back under control. It really makes you wonder whether virtual hearings are helping or hurting the process. Without the structure of an in-person courtroom, the sense of seriousness can feel diminished. I'm curious what you think about that.
I appreciate that, but I would still like a written.
You order the transcript. It's in the transcript.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court is not going to respond to your voice message. The court reporter is going to respond to you coming
the 36th
down.
district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is distinct.
Yeah, I was told to call the clerk the day that I was locked out, the moment I was locked out.
We've moved past that getting locked out.
But that was my trial date.
Yeah, so I'm giving you
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now. A jury trial. A jury trial. I'm gonna let the jury of his peers hear what he has to say. July 23rd, 2024 at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that day. So you're trying to play with me. You could dismiss it today, sir.
God.
You literally violating my due process. You are literally violating my due process. You can't even give me a written excuse, but you're gonna all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. Excuse me, ma'am. I am in pro se. I'm in pro se.
Go wherever you want to. Final pretrial July 22nd. And the trial date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
Looking ahead, This case is set for a jury trial, and it's likely going to be challenging for the defendant. If you're interested in seeing how that plays out, let me know and I'll share it soon. As for this hearing, it feels like the defendant was able to push boundaries without facing immediate consequences. Many people would expect stronger repercussion for speaking to a judge that way, but Judge Perkins clearly chose a different approach. That wraps up this courtroom moment. Share your thoughts in the comments, and if you want more content like this, don't forget to like and subscribe. Thanks for watching and take care.